Hey folks, we are back. Today, we are looking at the FTC Funeral Rule. Oh boy, you are in for some fun. This is one of those ones where you better break out all your note cards, all your notes, record everything 3 or 4 times, start tattooing things everywhere, because this is insanely important. You understand the FTC Funeral Rule. The Funeral Industry Practices Trade Regulation Rule, or the Funeral Rule, went into effect in 1984. It was reviewed and revised again in 1994. So 10 years after, they kind of looked at things and said, okay, let's kind of fix some things here. 3 primary purposes. Give consumers the right to select what they want, okay, select funeral goods and services which they wish to purchase. You remember when we were studying how to be stupid in the funeral industry a couple of chapters ago, we had that one guy that told the son he had to buy a sealer. That's what the FTC is trying to stop. Provide consumers access to detailed itemized price information prior to purchase decisions. Prevent misrepresentations and other unfair deceptive practices in the sale of funeral goods and services. Well, requires that we distribute price lists with itemized prices of various components with mandatory disclosures. Any entity that offers or does sell funeral goods and services is subject to the rule. So remember that, goods and services. So if you go to, won't mention any names, but like Walmart.com, and type in earn, and all the earns pop up, all they sell is goods, no services. Busted. If you just do services but no goods, that would be odd. You probably wouldn't apply, but generally if you're selling services, you're selling goods, which is why we have issues. We have issues where we have people that are unregulated selling funeral goods, and they can do some serious fun with us because we are obligated to act under a federal umbrella. The primary item enforced by the funeral rule is the general price list. This must be given prior to purchase, contains a detailed itemized listing of the goods and services offered by the funeral home. Now, this must be given. This must be given when a person inquires about goods or services. I think this is going to be later in the lecture, but I'm saying it now in case it is not. That when a person inquires to you, wherever you are, about goods and services of your firm, you are obligated to give them a written copy. You cannot just say, oh, I'll email it to you, okay? You need to be able to produce it. So parts and explanation of a general price list. Introductory matters. It must contain name of your firm, address and phone number, the words general price list, and the effective date of the general price list. If you offer any of the following 16 services, you are required to list them separately with a price. If you do not offer one of them, you don't need to list it. You may list any additional services in addition to the 16 mandatory ones, okay? It is recommended that you list any and all goods and services you offer on the GPO. Best practice. Put everything there, complete transparency. Now look at those 16. Basic services, funeral director and staff. This is the only non-declinable fee that a family must. You can require this charge as a condition for any service you offer. So for instance, my former place of employment, when I left, I believe my basic services fee was $1,695. If a person came in to speak with me, I could charge them $1,695, services of the funeral director, to sit down and talk about their arrangements. And if they went somewhere else, I could collect my money. Many of us do not do that because that's the category of really crappy things to do to clients. But there are firms that do it because they do not want to have their time wasted. You spend 3 hours, they go somewhere else. What do you get the show for it? But if you wanted to charge them a basic services fee of $100, and that is your basic services fee on your price list, and you charge it for anything that walks in that door. Someone wants you to mail an obit, free obit, you charge them $100. It is what it is. Don't want to pay the $100? I ain't got to do it. Basic service fee is to include, which means if you do any of these things, you can charge for it. All of the stuff, services that are furnished by a funeral director in arranging nearly any funeral, the arrangement preference, planning, obtaining permits, etc., etc., etc. Embalming. If you offer embalming, you must list the cost of your standard embalming fee. You can list additional charges for autopsy or tissue donation cases. Notice that is not a surcharge, because you cannot charge surcharges for a contagious disease. Any other preparation of the body other than embalming is a mandatory fee. Typically, this can be used to include dressing and casketing, hairstyling, bathing and disinfection, refrigeration charges, etc. Services and facilities for reviewing. This fee covers the services of the funeral director, staff, and facilities for reviewing. Now, understand, the way to look at these things is, what if someone walked up to your door? There was I had a situation one time where a funeral director calls me from a county north of mine and says, I have an employee whose mother's passed away. She just retired. The employee just retired. Her mom's passing. We're going to handle all the services, but she attends this church down there, happened to be the Catholic church I attended at the time, and we need a chapel for a visitation. We need to leave her there overnight. What can you do? Well, what I could do is charge him exactly that, services and facilities for viewing. Funeral director, staff, anything he needs. That's included. So if someone brings you a body and they need to do a viewing, they had everything else done somewhere else, this is what you would charge them. And that's what I charged him. And I made sure that he had all the amenities he would normally have if he was a paying client. Coffee, cookies, whatever we normally had on display, he had. And it was an impressive firm. At his firm, he hires no one without a license. All the part-time employees, whatever, they have rotations, people serve. Everyone works with everyone. No one is part-time. It was a fairly impressive business model. You can have different prices for different lengths of visitations and different prices for public versus private visitations. Now, this is an excellent thing if you want a private visitation, where this is typically where you are making sure that unwanted people don't show up. You can build in the cost of maybe one undercover or one on-duty, off-duty law enforcement officer from your local law enforcement agency. So it's already there, and all you have to do is place the call, and they're already been charged. Okay? Services and facilities for funeral services. What if someone shows up at your door and says, hey, I got this body, I need to have a service, can I use your chapel? Well, funeral director has to be present, whether it's your chapel, so you are under supervision unless they're providing someone, right? Staff and facilities, you're going to want definitely your own staff there to make sure they don't trash the place. You can list separate prices for services in different locations. Main chapel, side chapel, memorial service, same exact thing. Covers services of funeral director and staff in your facilities with no body present. Memorial service could have an urn. It could be an empty casket. You could get a little creative with that, okay? A little creative with the body present, not present sort of thing. Graveside service. The way you remember this one is everything happens at the graveside. Nothing happens at the firm. Covers you, staff, and equipment to go to the cemetery and set things up for a service. This is not a committal. We're very clear about that. This isn't a little 15 drop and go. This is a graveside service. People are going to be there and stay there because everything is happening there. This could be anywhere between 15 minutes to 2.5 hours, depending on what they want at the cemetery. Committals are usually attached to a service somewhere else. You had a service somewhere, then you come to the cemetery and you do the drop-in and you go. Okay? So know the difference between these two. It's very important. Transfer remains to funeral home. Can be a flat fee, hourly, mileage, be a combination. Most of the firms I see will charge a flat fee within the county of their operation and then loaded mile afterwards. So if they have to drive 300 miles to get a body, they will deduct the mileage outside of the county to where they have to go. And then once they pick up the body, they charge from there all the way back. All charges relating to the transfer must be in the fee. You cannot charge just for a vehicle and then hit them for an employee, or just an employee then hit them for a vehicle. It has to be an all-inclusive price. Your hearse fee must be itemized. It can be flat, hourly, or mileage, just like your transfer. It can be a combination. Limousine, treat it like a hearse. If you do not own a hearse, if you do not own a limousine, you do not have to have these prices there. Common fact pattern. Common fact pattern. You work with a livery service. They provide you a hearse which they park in your carport. It is not your hearse. It is their hearse, and you leave their hearse for prestige purposes underneath your carport. My question to you is, do you need to charge a hearse fee, or list a hearse fee, I'm sorry, on your general price list? This is a trick question, because I know the answer. If you answered, well, no, Professor Finn, because I don't own the hearse, you are wrong. Okay? You are wrong. When you are looking at something from a consumer point of view, like the Federal Trade Commission is here, remember we talked about agency regarding transportation. You have to know that neither the driver, neither the vehicle is yours, or else you might be responsible for negligence, responsible with either of them, right? The Federal Trade Commission has ruled that if you park a vehicle outside your funeral home that is not yours, even belongs to another company, if a consumer can infer that it might be yours, you need to list it as if it is yours. So, moral of the story, if you do not have something in your business, like a hearse, do not get one from somebody else and put it on your property to make it look like you have it, or else they will find you in violation. Okay? Generally, a question I give you will not be something that really shady, because that is a really crappy way of trying to circumvent the law. It will be very, very clear. Very, very clear. Casket price ranges. Now, this is an important trigger. If you have a separate casket price list, okay, on your general price list, you must list the highest and lowest price caskets on your GPO. So if you have a 20 gauge hammer tone brown, I don't like them at all. They look very unattractive, but it's like, the $9.95, $4.95, cheapest one you got. You have to start at $4.95, and if you sell or offer the most expensive $30,000 bronze casket, then on your general price list, you must list $4.95 to $30,000. $4.95 - 30 grand. Okay? If you do not have a casket price list, you must list your caskets on your general price list. Okay? If you do not have a casket price list, all the caskets you normally sell must be on your general price list. If you have a separate outer burial container price list, you must list the highest and lowest on your general price list. You treat the outer burial containers for pricing purposes just like caskets. If you do not have a separate outer burial container price list, which are your vaults, your concrete boxes, you must list all your normal outer burial containers on your general price list. Now, trick question. Trick question. What if you use a brochure? So, for instance, you have a 15-page full-color brochure, and your general price list, your casket price list, and your outer burial container price list are all included in this 15-page, full-color, beautiful brochure. Do you need to put on your general price list pricing schematic, the $4.95 to $30,000, et cetera, et cetera? Or do you need to list all the prices? Let that percolate for a second. You have one booklet. It's all bound together that you give to all of your clients, and it contains all three documents. What do you put on your general price list? The range of prices or all of your caskets? You put in the price ranges, because your general price list and a separate casket price list and a separate outer burial container price list are all part of one big document that you hand out, but they are still separate items. They have their separate restrictions, name, dates, etc., that we will talk about each one of them. So be very careful that you do not leave something out by saying, oh, well, my casket price list is in the back. It's in the same thing. Doesn't matter. If it's not in the general price list portion, you have to list the range because it is a separate document, even if it is in a larger permanently bound item. So forward of remains is generally a package, the way I explain it. Okay, it's a package price required by the funeral rule. The price of the service is required. You cannot charge the basic services fee in addition to this. That's why I call this a package. It is considered included in the description. Must contain all service and merchandise charges. The forward another location. That means it has to include the embalming, the transfer, delivery to the transport area or agency, airport or whatnot. It has to include the container, all of it, forwarding of remains. You do not have to include the cash advances, airfare, tariffs, etc. Okay? Anything you do has to be included. Anything you have to pay to somebody else, tolls, whatever, okay, you could charge extra. I am telling you that if you pay tolls going to the airport, you should automatically just put a toll fee in there as a price. And the same thing goes with receiving of remains. If you have to go get remains from an airport or whatever, it is a package price. Now, pay attention. When you receive remains, that does not mean it is going to go right to the cemetery. Okay? If you receive remains, what is included is the pickup and delivery to the place of disposition. If they want to have services and everything else, that's when you have to jump back to our little buddy right here. And you add this to the receiving of remains. Because they're asking for a funeral service with a viewing and all sorts of other things. So you get to do things with a forward or with a receiving of remains because it is what it is. Okay? But the only thing you can't charge extra for is delivery to disposition, because it would be intended that you receive the remains and then you drop them off to place of disposition. Anything extra, you can charge a la carte. You do not have to include cash advances. Okay? Again, if there are things that you need to pay out, such as cemetery fees or whatnot, you do not have to include a cemetery, because who knows what cemetery they're going to use. So you have no way to anticipate a cash advance. And obviously, you don't have to include the other services, as I've already explained. The direct cremation or immediate cremation, again, a quote-unquote package price required by the funeral rule. You cannot charge the basic services fee in addition. It's considered included. Disposition of human remains with absolutely no services with the funeral home. It must contain all fees to perform the cremation. And under this heading, you must offer the following items. Price of direct cremation, if the consumer provides the alternative cremation container, the minimum required by law in your state. Typically, that is a corrugated cardboard box, okay? Which means you charge a fee, they give you the box that you cremate with the body. Price of direct cremation, if consumer purchases your minimum container. What is the price for the minimum container you use? Now, be careful there. If all you use, you never use the cardboard box. Your basic container is something a bit higher standard than that. That is fine. But that has to be your minimum. You cannot offer the cardboard box as an option past that. Your least expensive alternative container has to be on the bottom. And the price range between your least expensive option and your most expensive general option, which is generally your most expensive wooden casket eligible for cremation that you already offer in your casket price list. You can list anything else you want, direct cremation with scattering, direct cremation with mailing, whatever. But you have to list, at a minimum, the direct cremation price and then the cost associated with each one of these things here. You want a crematory. Your direct cremation fee should include your crematory fee. So you should not charge your direct cremation and then also charge a $150 crematory fee. You own it, okay? If you charge for direct cremation, use a third-party crematory, and they charge you $150, you can add that as a cash advance, okay? Disclose the fact. Disclose the fact that you use a private crematory, a third-party crematory. Immediate burial, another package price. You cannot charge the basic services fee. Must contain all fees associated with the funeral home, preparation and casketing, and then delivery to the cemetery. Delivery to the cemetery. Under this heading, if you offer an immediate burial, you have to treat it like a direct cremation. What does it cost if they bring you a casket? What is the cost if they buy your cheapest casket? And what is the price if they do an immediate casket? And dude, if they're paying $30,000 for a casket for an immediate burial, you should drop to your knees and thank glory for it. Let me tell you what. You do not have to include balls, cash advances, or cemetery charges. They're outside what goes into the burial. So now we're done with the 16 mandatory prices, and now we're going to look at mandatory disclosures that must be somewhere on your general price list. Choice of goods and services. This disclosure gives the consumers a right to choose only the items and services they wish. They have the power to do that. Should be printed immediately above the itemized, 16 itemized price listings. Okay? Non-declinable service fee, printed immediately in conjunction with basic service of funeral director and staff fee. Informs the consumer this fee is non-declinable. That has been included in the quote-unquote package prices we just talked about. Forwarding and receiving of remains, direct cremation, and immediate burial packages. An embalming disclosure is to inform the consumer they have the right to decline embalming. Must be printed immediately in conjunction with the listing for embalming. Availability of casket price list must be printed immediately in conjunction with the range of caskets in a general price list. You do not print this disclosure if your casket prices are part of the general price list. Okay? If you have to list, or if you do list all of your casket prices separately, you do not need the disclosure. If you're looking at my example of the big brochure, 20 pages, full color, and the casket price list is like, page 9, and your general price list is pages 4 through 8. You need to have this disclosure with the range of caskets in the general price list section. And the same exact thing applies for the disclosure for outer burial containers. Same rules apply to that. You also have to have a disclosure for the alternative containers for direct cremation. Mandatory disclosure that informs consumers they can use an alternative container. They do not have to buy a cremation casket. And it has to be directly in conjunction with the price for direct cremation. And you are free to offer packages in addition to anything else that you are required to have mandatory. You can make up whatever you want as long as you have all the minimums required by the rule. You cannot offer package pricing substituted for mandatory disclosures. Your package pricing has to be something separate. Now, you can discount your packages cheaper than the same service is itemized if you wish. A lot of firms do that. And I am telling you, if you do that, show them the savings, okay? Give them a column where it shows the price, the a la carte pricing of all the items, the total retail value, minus the discount they are receiving and the final cost for the package, so they can realize the discount. See, hey man, I'm saving $1,200 here. That is a good thing. That's not something I'm going to test you on, but that is a good practice, I think. And I am telling you, okay, do not reduce the basic services fee. Do not discount yourself. If you start playing with any of the mandatory fees, okay, you're going to run into trouble. The way that you put things on paper matters. So when we look at a statement of goods and services and you list your basic services fee and you want to give them a break and you want to cut that in half, do not charge them half for your basic services fee. So if it's $1,000, do not write in on that line item $5 for basic services fee. Give them a discount at the bottom. That complies with the Federal Trade Commission. They can match your general price list to your statement of goods or funeral contract. See, the cost is the same, and then what you choose to discount it, that is perfectly fine in most situations unless you're doing something real shady in regards to like hosing your clientele, and that can be determined, okay? Distribution of your GPL must be given for retention. They have to be able to keep it to any individual who inquire in person regarding funeral services, specific funeral home goods and services, or the prices offered by the funeral home. Right next door to my funeral home was a McDonald's. And it was my customary behavior every other day, every 3 days, depending on my mood and how much money I had, to go to McDonald's and get myself a sausage McMuffin and a large iced coffee with cream and sugar. One time, while driving through the drive-thru, picking up my stuff. A lot of parishioners from my church work there. Their children work there. Gentleman behind the window says, "Hey, I've been meaning to ask you, my dad's really not doing too well. How much does it cost for a service?" So I ask you, am I obligated at that point in time to give him a general price list? I am in the drive-thru at McDonald's. The guy behind the window knows I'm a funeral director. He's seen me at church, and he asks me how much it costs for a funeral service. And I'm asking you, the student, must I give him a general price list? If you answered no, you are incorrect. Look at the rule. Individuals who inquire in person, of a physical person staring me in the face, even though I'm at McDonald's, regarding funeral services or prices offered by my funeral, I'm obligated to give him a price list under federal law. Did I? You betcha. Now, I'm in the church parking lot. I'm coming out after service. I used to sing in the choir. I was the crucifer for nearly a decade at my Catholic church. Person stops me, "Hey, I've been wondering, I want to come to make my premium. What do you charge for a cremation at your place?" Am I obligated to give them a price list? Well, you know damn well if I got to give it to someone at the drive-thru window at McDonald's, I'm going to give it to them in the parking lot at church. Lesson learned, folks. Under federal law, by the letter of the law, when a person inquires, we have to give it if it is in person. We don't have to do it if they're on the phone because they're not in person. So watch out for fact patterns like that. That is a common trick. Whenever you have the face-to-face discussion, you need to physically hand a GPL to the individual making the inquiry. Okay? You don't have a choice in the matter. If a person is walking to their car during a funeral and they decide to do that crappy thing most people do, "Wow, I really like this. How much did you charge for that? I want to come in and do my pre-need. How much would it cost me for something similar?" They have inquired face-to-face. And you do not want to find out that that was one of the FTC agents who are now going to nail you with a $16,000 fine because you refuse to give it to them or blah, blah, blah. It really stinks. Okay? Remember what it said earlier in the book. Complying with the law is a cost of doing business, and making a good faith effort to make things work with your business raises your standard. So, Professor Finn, what would you do in that situation? Well, in every situation when I'm trying to get people to their cars and they say, "Wow, I need to come do my pre-need. How much would a funeral like this cost?" Well, sir, I would be happy to discuss that with you. Here's my card. Here's my general price list. You can look this over and call me with any questions. Set an appointment to come in. But I think you and I can both agree this is probably the most inappropriate time for both of us to discuss it, considering that we have other duties that we have to attend to regarding services, the immediate services. Boom, every single time. Perfect. Away we go. It's done. You cannot say that one is available if they want it. If they ask, you have to give it to them. It is simple as that. The trigger event is the face-to-face meeting. Okay? The only exception to this rule is if a person is asking permission to embalm, it is not a triggering event for the GPL. As soon as they ask how much the embalming costs, now there's the triggering event. So all of your removal staff should have GPLs on hand so they can immediately hand items to people. It also applies to arrangements. Everything with the FTC Funeral Rule applies to pre-need arrangements as well as at-need arrangements. You must give it for retention. You cannot ask for it back, nor can you charge a fee for it. It is also improper to place the GPL in a binder where it can be inferred or implied that it is not for them to take. Now, one of the common test questions that students here in my institution have a real issue with, and I kind of had an issue with it too from a former professor, is that in his test factum, he would say that a family walks into a funeral home, they sit down with the funeral director for arrangements, and the funeral director gives them a binder to take home. It says right on the cover of the binder, for the family of, John Smith. He walks them through it. He shows them the general price with everything in there, and they go through the arrangements. It's a question of would that comply with giving them a general price list? And he would say no, because it's in a binder. Now, I think that's really crappy, because if it is very clear that you are giving them the binder and all of its contents, they are in compliance. Generally, people will not try to push that route with you. They'll say it's in a binder on the desk, pre-existing people walk in. Boom. Does not infer that they can take it. It's in a binder. Binder has a clear cover. don't care. It's in a binder, okay? But if your factum states that you have indicated expressly that you are giving them a binder, I would infer that you mean for them to keep the GPO. I would most certainly comment on a question like that if I see it on a test or a professional exam, saying, well, you know, Federal Trade Commission requires that we give them the general price list to keep. The fact that it's in a binder should be irrelevant if you have stated that here is your general price list, here is this entire binder, it is everything in here is for you to keep, you have complied with the law. So now if your casket or your general price list does not list your retail price of every casket offered, you have to provide a separate casket price list. There are no mandatory disclosures on a casket price list. Lucky you. However, it has to have the name of the funeral home at the top, okay, identifies who you are, contains the words casket price list, you wanted to know it is a separate document, and then must contain the effective date of the casket price list. And always make sure you're distributing the most current versions of any of your price lists. All caskets and alternative containers which a funeral home has in stock for sale or which are part of your regular offering, not just inventory, but offering, must be listed on the casket price list along with the retail price. So again, especially with your alternative containers, if you offer the cardboard box at $125, $50, whatever it is, that is your cheapest cremation container, and you do not put it on your casket price list, but instead list the next one up only provide the cardboard box if they inquire, you are in violation of federal law. You must list the most inexpensive in the same way as the most expensive. You must display the most inexpensive in the similar manner of your most expensive, blah, blah, blah. Special order items, caskets, do not need to appear on a casket price list because they're special order. There's no requirement how you list them, what order they're in, what type of caskets must be stocked. The sole purpose of this is so that a person can look at your document and see what prices are. If you offer direct cremation, you should have readily available an alternative container or unfinished wooden box, whatever the minimum is in your area. In the listing, the caskets and alternative containers, the funeral director should provide a brief description of the exterior construction and the interior lining, so you have an idea of what a product is. Corrugated cardboard material, laminate wood container, oak laminate container, solid hardwood container, and then with interiors, blue velvet crepe, blue linen interior, shirred, velvet, cream, whatever it is. You should be able to identify the casket in its general description overall. Metal casket should have their gauge. Okay, so with metal caskets, make sure you list 18 gauge, 20 gauge, stainless. If there is a prominent exterior trimming or coloring, note it. There is no requirement that you list the manufacturer's name or a model number, although that may be in your best interest for tracking purposes as well as for down the pike. If it's on a pre-need, that casket may be discontinued and you need the direct substitute for it. So having an old manufacturer's number would be a good idea. So unlike a general price list, a casket price list must be presented prior to showing caskets, or must be presented as soon as they inquire about caskets or caskets prices. Don't need to keep it. You can ask for it back. Okay? It can be presented in the form of a binder, chart, computer, don't matter, as long as there is the disclosure on your GPO. Okay? Now, you offer your caskets via computer. Okay? You must present the casket price prior to looking at the caskets on the computer. If offered for a showroom, the door to the showroom needs to be closed, a casket, prior to giving them the price list. It could be in or displaying caskets prior to giving them the price list. If a person says, we're looking to buy a casket, how much is that going to cost us? As soon as you give them the general price list, you should immediately be showing them the casket price list. No questions asked. It is not rocket science. And a good way to get all of this done, okay, is to have all of them in the same document, like I've said with the brochure. All three documents are there. If you contain it within the general price list, even better. Make sure they know it's there. And as long as you say, folks, our casket price, this is right here, we'll discuss this when we start talking about caskets, and you preempt it before they've even brought it up, before you've even shown it, you've already complied with the federal trade. It took you like 3 seconds to say it. Very similar. We've seen the rules regarding the outer barrel container. They, for the most part, mimic the casket price list. Name a funeral. Words, outer burial container, price list. You cannot paraphrase any of these required words. They must be these words. The effective date. Now, all containers regularly offered should be on there. Special orders need not be listed. Brief description of the item. And again, manufacturers, model numbers, who cares? You don't have to list the stuff. Same exact things apply for the casket price list and the outer burial container price list. However, the outer burial container price list has a mandatory disclosure, okay? For the purpose of the PowerPoint, I don't like putting a lot of this, stuff in the PowerPoint itself. I have provided this to you in the online learning suite. It is part of your required reading, and you need to know that this is something that is in this price list. And you can always get the most updated version directly from ftc.gov. Distribution follows the same thing as the caskets. Anytime you will display or discuss, prior to doing that, you need to give them the price list. Not be given for retention, and you can use any materials you want as long as they can see the prices all on the price list. Okay, so for instance, you cannot have a binder of your different vaults and not have a casket price list. Just because your prices are clearly visible does not excuse you from having a price list. You must have a price list for the consumer to see. And I will caution you again, if your arrangement room has some of the old models, the really cool old vault models, the miniatures, you should probably do your best to give them these things like an outer barrel container price list prior to them seeing it. You don't want to get that one person from the FTC that says you're displaying vaults and you didn't discuss this. We've been sitting here for 45 minutes. I'm going to fine you. You will get that person. So finally, we're done price lists. Yay! Now we're going to look at the statement of goods and services. In many areas, this is the source of the funeral contract. The purpose of this document is to provide consumers with an itemized list of their purchases at the conclusion of the arrangement. Entries on the statement of goods and services must reflect the entries in the GPO. Remember earlier I said never discount your standard prices, your basic services fee. Take the discount in the appropriate section. The numbers have to match. Statement of goods and general price list, casket price list, everything. Itemized price must be written on the statement. You cannot individually lump things together. So for instance, you cannot take a hearse, transfer vehicle, and document courier and charge automotive. You must list hearse, removal, vehicle, whatever it is. They have to be itemized. Now, if a consumer purchases a package funeral, the funeral director should list the purchase of the package and along with the name of the funeral package as well as every item included in the package. You don't have to include the individual prices for the individual items, but you must list what's included. Good practice is whatever arrangement software or contract you're using is if you write in the name of the package and then you list all your basic services and automotive and preparation fees, write the word or letters included, INCL, next to everything in the package so that there is no doubt what is included in the package price. You also need to list all your cash advances. If a cost of an advance is not known, list a reasonable estimate. If you know that airfare is about $700, you should probably list $725. A little bit higher, but refunds rather than extra costs. And I personally like to get the financials out of the way immediately. So if I can give a reasonable estimate for airfare, and I know that American is charging $688 for shipment to New York, I will list $700. I will tell them this is an estimate. I'll get the actual charges from the airline. And understand, if this is more, the airline charges me more, I will have to ask for more. But I have purposely asked for more now, the standard charge about $688. So if something does change or whatever it might be, that you will receive a refund. And if you find out that maybe you need death certificates later on at $8 a copy, we already have some money here that can be used for that if an issued. So if you disclose things right up front, families appreciate that. So with the statement of goods and services, outside of listing accurate pricing for anything you've charged, listing all the items included in a package, there are two, possibly three disclosures. The disclosures in a statement of goods and services, which must be separate and distinct from your price lists, is listing of legal and other requirements, embalming approval, and marked up cash advances. So listing of legal and other requirements. This informs consumers that they will only be charged for those items that they selected or that are required. It matches, or at least paraphrases, is very similar to the disclosure we saw in the general price list about 20 slides ago. This mandatory disclosure can be printed anywhere on the contract as long as it's visible. Okay, don't hide it. The companion requirement to this disclosure is the provision of the Funeral Rule, which mandates that a funeral home lists on the statement any legal, cemetery, or crematory requirements would compel the consumer to purchase specific good or service. So, in one area that you might have this top statement, and then underneath it is the other requirement portion. So, for instance, what I see a lot of is in many jurisdictions, a medical examiner or coroner must provide a cremation permit or authorization number, and they charge a fee for that, anywhere between $25 to $75. And then yet when I look at the required other requirements section in the line of anything you've had to purchase here as a result of legal obligation by state or local policy of cemetery, I see the line is blank. And I think that is bad. The line's there for a reason. Write in coroner fee, medical examiner fee. Write in outer burial container for cemetery. Write in alternative container for crematory. Comply with it. Write it all in. If you are this transparent, anytime anything goes wrong, it is very hard for someone to pin something you didn't do on you because you have left nothing blank and really excel at what you do. Second disclosure, embalming approval. This disclosure, again, it can appear anywhere on the statement. Generally, probably should be around the area where you are charging them for embalming because it makes sense to kind of go over and read it to them. Explains the requirement for embalming. If there is no requirement, write in the word none because embalming wasn't done, and tell them that. Typical reasons for embalming: family consent, funeral home visitation, interstate travel, public visitation, whatever. We know air travel is one of the good reasons, but we can also ship using cold packs or dry ice if we have to go by airline. And the third or optional disclosures, the marked up cash advances. If you add a surcharge to any of your cash advances, or if you retain a portion, a rebate, a commission, whatever it is from the supplier of a service that is not passed on to the consumer, you must have this disclosure. You must also identify those items that are marked up. You purchase flowers from a florist, you charge them as a cash advance, and you take a 20% cut. You must list that you charge, the cash advance, and you must disclose, asterisk or whatever, that the flowers is what's there. If you charge a cash advance for a catering fee, you must do the same exact thing. So if you charge $1,000 and you only are billed $700 by the catering agency, you must disclose you mark it up. If you never mark up cash advance items, then you don't have to worry about this. You also don't have to disclose the amount of the markup. The disclosure must be made immediately in conjunction with cash advance items. So unlike the embalming disclosure or the listing of legal and other requirements, you must put the marked up cash advance directly in relation, in conjunction with the cash advance items. So when do you distribute the statement of goods and services? Presentation is to be made at the conclusion of the arrangements. It should be filled out completely and show the total price for the funeral. Signatures are not required, but highly recommended since the statement can serve as a funeral contract. You're going to say, well, Professor Finn, hold on a dang second there. We get signatures in ours all the time. That's the law. That is your state law. Under the federal law, a signature is not required in a statement of goods or services. It's meant to be a price disclosure for the individual, for the client. State law may require those signatures. Florida doesn't just require, for instance, their signature. It requires the signature of the funeral director as well. You cannot let them walk out without one of these. So what happens when someone calls you on the horn? What's up, hey man? Got to bury my mom. What's the charge to bury my mom? Well, you got to give accurate pricing over the phone. You're prohibited by the funeral rule to refuse a price inquiry. You're refused by the funeral from making the caller identify in order to obtain pricing. If they inquire, you have to give. So, Smith Funeral Home opens up across the street from your firm. You've been in business 100 years. Mr. Smith walks in, dressed in his suit and tie. He's got his name tag. He pulled up in his car with his logo right in front of your carport, being a world-class epic jackass. He says, hey, I need your price list. How much you charge for a funeral? So he can undercut you. The price wars starteth. Must you give him a general price list? If he said, hell no, he's a competitor, you answered wrong and have opened yourself up to a $16,000 fine, which you know Mr. Smith will report you because he can. Doesn't say you have the right to refuse a competitor. If they walk in and they ask for a price list, you have to give it. If you do not, you're in violation of federal law. Now, Mr. Smith knows that on the first of every year, you change your price list. Well, instead of coming over and being a world-class jerk like he was last time, he just calls you on the phone. Says, hey, I need your prices for a direct cremation. And he's just going to, update his records accordingly and undercut you. You have to give it over the phone. You can't force him to identify himself. You can't look at the caller ID and see it's him and not give it. You are obligated to do it. If a funeral director or trained staff member is not available to provide information, a message should be taken and call returned promptly by the funeral director. I am telling you, as a best practice, if you have someone that is answering your phone that is an employee, not an answering service, but an employee, and they are not trained or good to provide information, probably should not be answering your phone, okay? Calls taken by answering machine, answering service, or evening caretaker who is not responsible for pricing inquiries must be returned promptly. Okay? If you do not return the calls promptly, which I know has a reasonable amount of interpretation, you can be found in violation of the funeral rule. You need to provide pricing. So 6 areas of misrepresentation you have to watch out for. Embalming, caskets for direct cremation, out-of-burial containers, legal and cemetery requirements, preservative protective claims, and cash advance items. Embalming disclosure prohibits misrepresentation and requires the funeral director to inform the consumer that embalming is not required by law except in special circumstances. By placing this in writing on the statement of goods, you have complied with this disclosure, even if you haven't said it prior. You should still probably read it to them anyways. It is also a violation to inform that embalming is required as a practical necessity in the following: direct cremation, immediate burial. If the direct cremation or immediate burial does not require embalming, do not say it does. Now, you are contracted to do an immediate burial. Okay? Cemetery calls you back and says, hey, yeah, these guys have a mausoleum crypt. We can do the drop-in. It's not an issue. Opening, closing, 1700. Let your client know. We do require embalming in a gasketed sealing casket to go into a mausoleum crypt. Can you charge embalming? Can you tell them that you must charge embalming for the immediate burial? Okay? That is my question to you. Next question, must you sell them a sealing casket? So to the first question, must you charge them embalming? Yes. They cannot make use of the cemetery unless they have the body embalmed. That's a cemetery requirement. So you should tell the family that, state law doesn't require it, we don't require it, but the cemetery requires embalming for anything placed above ground. So you elect to use the cemetery crypt that you have, you will have to have the body embalmed. We will have to obtain permission, or else I cannot bring the remains there. Sealing casket. Must they buy it from you? That is a trick question, is it not? That's Professor Finn throwing one at you. The answer is no. They don't have to buy it from you, but they must buy one. Okay? Of course, you'll want to try to sell it. The family must purchase a sealing casket because that is a requirement to the cemetery. Both of these things need to be listed on the state goods and services for legal and other requirements. Okay? If refrigeration is available, and there is to be a funeral with no viewing, and there is to be a closed casket, there is no reason for you to force embalming on someone. Okay? Give people their options, let them decide, explain everything. You must make alternative containers and unfinished wooden boxes available for people seeking cremation. They don't need to buy a $5,000 casket. It's a violation to say that an outer burial container is needed if it is not, or to say the state law requires one if it's not. Don't say state law requires the cemetery to use one. The cemetery requires it. You made a misrepresentation. Presenting an outer burial container or outer burial container disclosure satisfies this requirement generally. But watch out for what you say, okay? Always obtain updated rules and regulations from a cemetery so that you do not misrepresent yourself in front of your client. Now, I will tell you as a matter of practical instance that I have never guaranteed anyone needing anything at a cemetery. It's not what I do. I'll make a general statement. Folks, be aware that if you're looking at burial at a cemetery, chances are you're going to have to purchase an outer burial container. We will look at those. I will verify that one is necessary. But as of the last time I utilized their services, a week ago, 2 weeks ago, whatever it was, last time I went to the cemetery, they did require one. So let me explain these to you and what they are, and then at least you'll have an idea, and we can assist you with the purchase if you want us to. Legal and cemetery requirements. This is a catch-all against any other misrepresentations. Also explains why you should list them in the appropriate place in the statement of goods. Write anything you feel you need to put into legal and other requirements, okay? So, for instance, even the best of us get charged by someone for something, trying to get a free lunch, trying to get a free bill, whatever it is. And I got accused of a swapperoo on a casket. And what happened was the casket that was ordered was now discontinued. And I had to provide like or similar merchandise. Well, it turns out that the casket company had a very similar casket, identical in every way but the corners, okay, which was not the big deal. 2 months after the funeral, I get a notice from my state that there is a formal complaint against me, and I need to provide documentation because I pulled the old casket swapperoo. All I had to do was send a copy of my statement of goods, legal and other requirements. It said whatever the name of the casket was, for the sake of argument, I'm just going to say the Crown Pieta casket was discontinued. Crown Casket Company's direct replacement to the Pieta was the Sympathy casket, which has been used for this funeral arrangement, and legal and other requirements. You know what happens to the complaint after that? It's done. There's no recourse because I listed it. Had I not listed it, imagine all the other things I would need to go through to prove. Instead, I faxed one form and it was over. Preservative and protective claims. You may not represent to consumers that funeral goods or services will delay natural decomposition of remains for a long or indefinite period. Do not make those type of warranty claims. You can state the body is temporarily preserved with embalming, but never state that this is indefinite. And you're prohibited from making misrepresentations regarding protective features of vaults and caskets. Any claim you make should be able to be proven. Use vault company graphics, use their own literature. If they want really specific information, you should put people in touch with representatives who construct and sell those things on a regular basis. If you do that, then I'd say you are qualified. We've already beaten cash advances to death, but list all your cash advances. If you don't know the actual cost, provide a reasonable estimate and provide the disclosure if you mark any up. It's not hard to keep yourself out of hot water. A lot of the reasons why this is all here is so we prevent something called a tying arrangement. Tying arrangement exists when a seller requires the purchase of an unwanted item in order to obtain a desired good or services. If you only offer services to people to purchase your merchandise, this is a tying arrangement. Oh, Professor Finn, don't we create a tying arrangement with the basic services of funeral director and staff? Yes, every single time. And the Federal Trade Commission states that that is acceptable. We can charge that fee with anything we do with the exception of the forwarding and receiving of remains, direct and immediate burial, because then it is included. That is the only quote-unquote tying arrangement that is permissible. But if someone comes and says, hey, I need to do an obituary, I need you to fax an obituary, and say, okay, well, my standard services and fees for basic funeral director and staff is $100, and now I have to show you a $1,500 casket, because unless you buy a casket from me, I'm not going to do anything for you. That's a problem. So again, we discussed the non-declinable fee. Legal requirements, legal and other requirements. So it is not a tying arrangement that they have to have embalming to go into the mausoleum crypt, right? Cemetery requires it. Make sure you tell them the cemetery requires it and not that the state does. Impossible, impractical, or excessively burdensome. Well, that one's always fun. So the funeral provides that funeral directors are not required to honor requests for a combination of goods and services that would be impossible, impractical, or excessively burdensome to provide. Although you may make the initial judgment, remember the FTC is going to make the final call. Your book references unembalmed remains for public visitation. It dates the book. Poor reference. This is becoming commonplace with green burial practices. I really do strive hard to try to find a way that's impossible, impractical, whatever. And maybe, you know, it could be something along the lines are that if a person wants you to have a Viking funeral, okay, you're probably going to have to tie them to some EPA law or something, but then we're back to the legal requirement. But if something really, really crazy, you can basically refuse it, okay? Third-party merch, you will accept anything somebody brings you, okay? You cannot charge a fee to inspect, handle, or accept delivery. You do not have to actively assist them in acquiring the merchandise. It's a passive obligation. Your book says you're required to accept the casket but not store it for a long period of time or be the one to receive it from the airport. If you do wish to accommodate the request of storage or pickup, you can charge for it. My personal favorite are the people who come into my funeral home when I was in practice, sit down with me, don't like my prices, and then want me to help Google search competitors to find a more competitive price, to which, realistically, I'm not going to do it. That's like walking into Pete and asking them to call Domino's and order something for delivery to the location they're standing at. You know, it's really crappy. So you do not have to actively help them. You can offer discount on your merchandise from funeral homes as an incentive to purchase your merchandise over a third-party supplier. And you can even restrict, this doesn't create a tying arrangement. If the family is going to choose a package from you, and it is very clearly listed in your package pricing, okay, that in order to receive the benefit of package pricing, you have to purchase the merchandise through the funeral home as well. The FTC does not consider that a tying arrangement because they are free to select exactly what it is that the package includes at full retail price and provide their own casket. Take note, if you normally assist your regular casket supplier, so sake of argument, Batesville Casket, the truck pulls up and you always go out and help the guy unload the casket, you need to do the same type of service with your third-party delivery personnel. Now, third-party deliveries may sometimes happen. They show up and they bring it in a shipping container, okay? You can require the third party to unwrap and unbox the casket. When Batesville shows up, they don't show up with a big wooden box and you have to hit it with the crowbars. So if a third party comes and does that to you, you need to have them open their junk up so you can basically look it over, make sure it's fit for the purpose. You have some minor obligations with this third-party merchandise. So before we go on to the next section, a couple things I want to reinforce. If a person is delivering a third-party casket, remember we can't refuse it. Now, if it is unpackaged in front of you and you notice that the casket is crunched in, think about some of the cases we've read in the book where, you know, the lid is all bent. You see the dead person's face after you've closed the casket, that type of craziness. You have an obligation to call the family, okay, and let them know the condition of the merchandise and how it was received, and let them tell you what they want to do about it, okay? If you can't get a hold of someone, you're basically just like accepting it, and the family's going to have to deal with working out a replacement. So you might want to have those type of frank discussions, like right up front with someone. Now, I'm not saying use this as a sales tactic. It's a very good sales tactic, though. But discuss it. Now, if this merchandise arrives damaged, what would you like me to do? Where can someone give me a number that I can call immediately so I can get answers as to what you want me to do, or so I can send pictures or have someone come down and look at it? Because I don't want to sign off and accept on something, and then you have to eat a new delivery and a reshipping charge. So have very frank discussions with your clients. You know, you're not screwing them on this. You know, let them know if they show up and they have a box, we're not under an obligation to uncrate it. The shipper has to do it. So prior permission to embalm. This is one of those commonly tested areas. Is a violation of the funeral rule. The charge for embalming, except in the following, when state or local law requires it, be sure to list that on your contracts and on the statement of goods and the legal and other requirements, if it's not already there. Prior permission to embalm must be expressed, not implied. Preparing the body or selecting a funeral service for viewing is not sufficient. You must ask, and they must give prior permission to embalm the body. 50-50 chance that writing a pre-need that includes embalming would be implied permission. I doubt that, okay? You really want a statement given. And then you run into concepts about interfering with right of disposition. I don't know, okay? If you embalm the body without permission and or if the state law does not require it, you cannot charge for it. It's as simple as that. Okay, this is true and even if they later provide you permission. So if you embalm the body, you didn't have permission to do it, you can't charge for it, even if they choose something later. If you did it negligently, okay? You got body, you just embalmed it. Didn't even ask for permission, didn't do nothing. Now, here's the way you can charge, okay? Exigent circumstances. All three of these conditions must be fulfilled to declare exigent circumstances. You must be unable to contact a family member or other authorized person after exercising due diligence. You needed to make some good faith effort to find someone. Funeral director has no reason to believe the family does not want embalming. Can't find some pre-need. It was all set up for a visitation and funeral. That's the last several funerals you've done in that family. It's common in your area. And after embalming, when you finally do get a hold of someone, okay, you inform the family that if they choose a funeral that does not require embalming, no embalming fee will be charged. But that a fee will be charged if they select a funeral that does require it. So if you've tried to find someone that can't, we'll say for the sake of argument they're on a 2-week cruise, okay? You have no reason to believe they don't want it because that's what they've always done in the past. And then 2 weeks later they come home and find out mom died. You sit them down and you say, well, you know, we didn't know what to do. We haven't done anything except embalm the body because the fact of the matter is the sooner we do that after death, the better the results are. And under the law, if you select a funeral that includes, you continue with the pre-arrangements the way they are, then we will charge for the embalming. And that is already included in the pre-need. There is no extra cost to that. If you change the arrangement so that you choose a service where embalming was not required, then we will not assess it. But then we are looking at changing a contract and away we go. Okay, that's another discussion for another time. Well, how long do you hold these pricing documents? Well, 1 year from it was last distributed. My advice is I'm telling you, try to keep these things as long as possible practically because they really do assist you with old pre-needs that may have not been filled out appropriately so you can determine pricing and whatnot. If you begin using a new list on January 1, 2013, the list you used prior to that must be retained until 1 year later. Copy of the statement of goods should be retained for a 1-year period from the date of the arrangement conference, but be aware of what your state law is. So, for instance, here in Florida, you are required to hold that additional time. I think it's 7 years from date of arrangement. Funeral Rule is enforced by the Federal Trade Commission. Fines range from $16,000 to $100,000 as well as refunds. Okay. In addition, there'll be state charges and fines. You can choose to pay the fine under the Funeral Rule or join the Funeral Rule Offenders Program to the NFDA. I think you get a little, name badge and merit badge for that. You pay a lesser fine. You must participate in educational activities through the NFDA for 3 years. Most funeral homes go this route. They pay a little bit less than the $16,000. They pay, whatever the lowered fine is. Then you have to pay the transportation costs and go to the conventions and stuff. Those conventions are pretty good. I recommend you do them. So 1999, they reviewed the rule. They really haven't done anything. Not in your book, but it does apply loosely. Know about this. In June 2010, the FTC instituted the red flag identity theft rule. If you're a funeral home, cemetery, or crematory that extends credit, assists customers in arranging for credit, and we're going to discuss that in a separate chapter, or accept multiple installment payments, more than 2, you may need to comply with this new rule. December 2010, Senate Bill 3987 was passed and signed by the appropriate people, which clarified which funeral businesses would be covered. And funeral business that obtain or use credit reports in connection with credit transactions and furnish information to consumer reporting agencies in connection with credit transactions. Folks, this was a long one. Thank you for your patience, and we will see you next time.